Insurance company, only by working with a lawyer like this will you ensure that you have been best to get the money you need and deserve. Maintenance and cure. Maintenance and cure dates back to ancient times, and it is idea that someone working aboard a ship has certain like if he or she is injured on that ship, regardless of any negligence, work aboard ship is dangerous and risky, and it was long ago decided that anyone willing to work in this condition was entitled to certain benefits in case of injury or sickness. This ancient law has been passed down to modern time, and current maritime law include this provision to ensure that injured seamen are given maintenance, money for everyday living expense, and cure payment for adequate medical care. If you are a seaman and you were injured on the job, you have certain right guaranteed by this law. Your employee, regardless of negligence, is obligated to provide with you adequate compensation to meet this right. If you are not receiving what is within your right to get, contact a lawyer knowledgeable in maritime law to help you take the next step. Maintenance. Maintenance under maritime law refers to cost of maintaining yourself and your day-to-day life. When you can't work, on in simple terms, the room and board. If you can't work and earn a wage because of an injury aboard a vessel, this aspect of the law entitles you to the money you need to pay rent and at least to buy food, to pay for insurance and taxes, and to cover any other necessities related to your home. The right to maintenance from your employer comes from the fact that a ship owner is responsible for housing and feeding you. When you are aboard a ship, this extends to your daily needs when you are off the ship and unable to work because of an injury or sickness. Anything that is not a necessity, like a cable bill or gas for your car, is not covered under maintenance. The law is specific to household necessities. Cure. Cure is related is your injury or illness caused by being on the job as a seaman. Whatever medical care you need as a result of that illness or injury should be covered by your employer under the law. This includes medical bills but also medication, transportation to medical appointments, and any kind of responsible medical treatment like physical therapy. Maintenance and cure. For illness, the right does not apply only to injuries that occur aboard a vessel. Working on a ship is a dangerous and risky job, but accidents are not uncommon. But you can also get sick because of your work or simply while you are at work. Your illness does not have to be related to your duties or the environment of the ship. If you are too sick to work and your illness developed while you were aboard the ship, you are still entitled to maintenance and cure from your employer until you are well again. The duration of benefits. The right of living benefits and care lasts until you reach what is termed maximum medical improvement, or MMI. MMI refers to a point which you have been treated medically until your condition cannot be improved anymore. This could mean you are fully cured or health, but it may mean that you are living with a chronic condition. Either way, your right to maintenance and cure expires when your doctor declares you have reached MMI. The rate of benefits, the rate of paid out for the right of cure to an injured seaman should be exactly what the medical expense cost, not any less. There was a time when employers paid less than the actual living expense for maintenance, but court case challenging the practice of underpaying for maintenance were successful. Employers now must pay the actual living expense of injured seamen. You have belonged to a uniform on your term contract may include a provision for the rate of maintenance that apply to all members, regardless of your actual living expense. However, the law regarding union maintenance rates is interpreted differently in different parts of the country. A personal injury lawyer experienced in maritime law can help you figure out if your union membership affects or determine your maintenance rate. So guys, the difference between maintenance and cure and the John acts as a seaman with an injury from being on the job. You have more than one source of protection under the law. The major difference between your right under the law and those under the Jones Act is related to negligence. According to the law, your employer has responsibility to compensate you regardless of who. If anyone was at fault for your injury or illness, you have no burden to prove negligence on the part of anyone, even your employer. If you are injured and you can prove that your employer's negligence contribute to the incident, you don't have the right to sue for more compensation under the Jones Act, in addition to costs for living and medical care. The Jones Act allows you to request damage for lost wages and pain suffering. Qualification and maintenance and cure. To qualify for these rights, you must meet the requirement that define a seaman. These are the same as those required by the Jones Act. A seaman, according to both laws, is someone who spends at least 30% of work time aboard a vessel, does work that contributes to running of the vessels, and does work that takes place on navigation water. When you have been denied benefits if you have been injured on the job, you have no become ill because of your working condition and you meet the requirement of being a seaman.